Think so?
You can ask him.
I will. Yes.
Tell him I'm here.
I will ask him.
You're intimidated.
No.
Certain other commissioners.
Yeah. Yep. Well, I'm just glad that he picked me.
I am.
Are we on mute?
Probably not.
Posted by.
I'm just playing. I was playing.
Busted.
Anyway. What they do is they certify the batteries.
Oh, yeah.
What's going on? So-
Okay. I thought I saw him just briefly.
Yeah.
But
No, I
anyway,
think
I
we've
want
had
you-
that conversation before.
Yeah, and I just want you to know that they were from the ages of, I assume with appropriate authority.
I assume, I don't know. I have to stay in my lane these days because I don't have enough time to do everything. I wish I could get more involved in some things, but Haley, you're in two places at once.
Yeah, have to turn that off, right?
What I can do is out here is, does everybody now some?
Schizophrenia can work well. It can work.
Does it get to vote twice?
Right, yeah, no, I don't think so. Yeah. I think it was a matter of, legislation.
All right, I think we have a quorum.
Yeah.
And who knows?
Yeah.
It's a popular issue, but.
That you need your gavel.
Or stomp on the floor.
Okay. Okay, before we get started, I know we have quite a few folks online, but this is for the folks that are in person. Welcome. Judge Sexton is on vacation and so the Honorable Stacey Donovan will be cheering today. I do have just a couple items. Those of you who have not been here, restrooms are directly out the back and to your sort of right. We do have until the door is closed, we do have a card that you need to swipe. So if you go to the bathroom, try and grab the card because you may not be able to get back in. We also in the fridge have soda and there's cookies out here too, so please help yourself. But that's just some housekeeping stuff. Yeah, and just for notice purposes, we do have the number 3 item as far as new member Matt Levitt. We went back and looked, his appointment doesn't start till July, so that was our fault. Those of you who don't know Matt, he is with Holnick firm down in Wichita, Holnick, Stang, Gearing, and Levitt. And he will be filling the private attorney position. So we're really excited to have him on and have some Sedgwick County representation as well on the stage. So with that, I'll turn it over to Judge Donovan.
Hi, everyone. We'll go to the first agenda item, which is approval of the agenda with that edit of removing number 3.
No.
All right. Is there any objection or do you want any additions? All right. Seeing no additions or requests, we'll move on. Hopefully you've all had time to review the minutes from our January 23rd meeting. I'll ask for a motion to approve.
So move.
Second.
All in favor?
Aye.
Aye.
Any opposition? Thank you. This will pass. I hope you've all had time to review the edits to the forms. So we'll move on to that and I will hand this over to Scott.
Thank you, Chair. Excuse me. So as many of you are aware, this is a annual process that we do based upon the legislative happenings for the most previous session. The commission is tasked as statutorily to maintain the sentencing forms, felony sentencing forms for the state of Kansas. The forms committee is actually made up of members of the commission. They met last week to review the PSI, the journal entry, as well as the probation violation journal entry. Based upon the items that came up during the session, we have recommendations for you to present today. Ultimately, we would ask that you up for discussion certainly, but also approve those after this review. Our esteemed staff attorney, Chris Lyon, is actually virtually with us today, and I'm going to ask him to, we're going to start with the PSI and work our way through the forms. Some of these you'll note will be new things. There's new special rules based upon legislation. There's also some items that are administrative in nature based upon the KSAP implementation. And so that is going to be important as well. We'll kind of get back, both he and I will get background on some of these things, but they're done to, after many feedback or much feedback that we've received from CSOs as well as other stakeholders in addition to the legislation. And so we're trying to wrap this all into one big package for you. Judge, if you're, depending on what you want to do, we can either vote on all these separately or we can do them all together. So I'll turn it over to Chris and let him start with the PSI.
Thank you, Scott. Everyone, I'm Chris Lyon, staff attorney for the Sentencing Commission. And like Scott said, we had a chance to review the forms last week, look at the new legislation, and this is what we came up with. So on your screen right now, and I will let Scott explain or Peyton explain some of the administrative changes, and that was a lot to do with DOMO and KSAP. So I'll defer to them on those, and I'll focus mainly on the changes that were due to legislation. We had many new special rules. We had at least 5 or 6 House bills we had to integrate into special rules. This covered everything from firearms to transnational repression. So starting at the top of the PSI form, some of the changes were quite simple. If you go to the top, please, is that we looked at the dates, we changed those, and the 2 first changes were related to the KSAP feature. One is to add boxes as for filed and approved, and I will let Scott or Peyton tell you about those real quick.
Yeah, so as we transition from technically paper forms to the electronic version of the KSAP, we needed a way to be able to track which ones were actually filed within the KSAP. Are there other ones that are potentially approved to be outside of the KSAP? This was a reasonable way to actually do this. What will happen is if the forms are filed through the KSAP, they will automatically be checked as filed so that not only can the Sentencing Commission see that that was actually used through the KSAP, but it also will allow the clerks to see that as well. House Bill 2552 requires, as of now, the clerks to actually not, or precludes them from accepting anything that has not been approved by the Sentencing Commission. So this was the solution to that. If there are things or exceptions that occur outside the system, we will actually then be able to approve those, and they can actually mark the approved portion based upon that. But this would actually be not only for this year, but also all of the years going back through because the KSAP starts in 2016 versions. We hope we're going to capture 98-99%. There may be some folks that have absconded for that long, or cold cases, that type of thing that might have to be pre-2016. But hopefully the vast majority of the cases are going to be able to come under this umbrella. So that's the long-winded answer as to why we have that. You will see this on the other forms as well. We tried to place it on the cover sheet so that parties can easily be able to see that when they're actually pulling these up.
Scott, I'm sorry.
Sure.
I saw this as I was going through the forms. So I'm confused. Is this something that when I submit it through Domo is automatically going to get checked when what?
When it's submitted,
Submitted to who?
it will actually, it really won't matter that much. So when the PSI is there, it will actually get, if it's created in Domo, it will automatically be checked.
Okay,
So
so when
that the
I
parties
get
don't have
this,
to.
if they created it in Domo, there's already gonna be a box up by file.
Yes,
Okay, from my perspective, that is confusing because a filed journal entry or a filed PSI means something different than generated through KSAP. And then approved to me is, it's approved by who? It's approved by the state, it's approved by the defense, it's approved by the judge. Like, what are we approving? So when
Sure.
I looked at those as I went through these three, if it's automatically generated and no one ever sees that, then I guess I can see why it's clear to those that are utilizing. But if it's something that's going to be on something and it's going to be confusing as to whether it's filed or approved and approved by who, then I had concerns about using that language without any kind of distinction.
sure. Great question. When you see it, it will be filed. So it technically has a dual meaning in that when you see that PSI, it will have already been filed with the court. And we are actually in that process right now of integrating not only the journal entries and the probation violation journal entries, but also the PSI. So when that CSO hits submit, it will automatically submit that to the e-file. So when you see that PSI, it will automatically mean that it was filed. If it's outside of the system, but it was approved through the commission, then you will actually see the check mark that it was approved. But the clerks had concerns about how do we know where this is coming from? We also have kind of a backstop is they know where it's coming from because the Sentencing Commission is the sender on all of the KSAP stuff. So they'll actually be able to, am I still going down the right track, Peyton?
Yep.
So when they see that, they'll automatically know but that was the rationale in terms of why we were actually wanting to distinguish that. Plus, on our end, we'll actually know whether or not it's been filed through the KSAP or it's actually a different one, and we'll have to manually enter it on the backside for a while.
Does approved mean manually enter to you?
No. It potentially means that we actually approve, well, I guess to some extent it does.
Yeah.
Because we'll still have to approve it so the clerks can actually receive it. But yes, it'll be essentially outside of the KSAP realm.
Could we call it manual entry?
We could.
Do we need to distinguish if a CSO is having issues with KSAP and just does a PSI on paper? I mean, and then they file it, it's going to be rejected. So it's not even just a manual entry. It needs to be approved somehow that the clerks know this has been an approved form by the Sentencing Commission and they don't reject that form.
Who's rejecting it?
The clerks will reject it. That's per statute if it's not on a form approved by the Sentencing Commission or manner.
So the box is saying that this is a form approved by the Sentencing Commission.
Yes.
How is that not, and I'm playing devil's advocate a little bit here. Like, we have our name on every single one of these forms and we have for years. How is that not already the enough?
Sadly, over the years, they have actually been morphed into something other than what the forms have been. And so jurisdictions have, over those 3 decades, have actually added and subtracted. And so there are some jurisdictions previously that were using certain other things they've added. They've added things based upon judges' preferences and things like that. And so this actually gives the ability for the commission to state these are the while it may not have gone through the case app, it's been approved by the commission.
So could we not say that at the bottom where we have the sentencing journal entry, the sentencing line, and just say approved by? As opposed to putting approved up top?
I think the issue is that the clerks need a very quick way to look
Okay.
at the document before they reject it or not. And
We have 105 counties and 105 clerks that will be seeing this differently, so.
I
but
can
they'll be
see it
trained.
for the clerks. They're not gonna wanna go and look through every form and have to scroll down to verify that it was an approved form. I think having it up top is probably essential for them in order to see without spending a lot of time on everything that gets filed.
And
To know that
who
it's
clicks
approved.
the approved form?
That'll be based upon whoever is authoring the form at the time. So in this case, the CSO would obviously receive approval to create that outside of the system.
what would stop Sedgwick County from adding this to their form? For instance.
Well, we are not updating it from here on out. We are not updating anything except through the case app. So there will not be any other forms that we anticipate at this point to be put on the website or anything of that nature. So this will be within the case app. If they can't work it in the case app, then they'll actually have to make a request.
So there's a button for the CSO to click in case app to say that they're using an approved form?
That's what we're talking about right now, to add that or not.
Okay,
So.
no, I'm just saying
It's
on
not right
this.
now, certainly, but that would be it will start out as the default here, for example, as filed. But if for some reason they can't do that within the ambits of the form for some reason, then it will be. If it's, a 2015 case or something of that nature, then it'll have to be checked approved, so that we'll know that it's actually outside, the clerks will know that it's outside of the system.
Could we be more specific and say filed through app and alternate form approved by sentencing commission?
We can use whatever verbiage the commission would like. I think it's just going to be a matter of, again, an educational effort early on here to help understand. We have explainers we put on the website as we do every year as to what that actually means. Within the desk reference manual, we would also be describing what that specifically is. So there would be a couple forms of medium that the individuals would be able to understand what we're trying to do here.
I'm not trying to belabor it. I know this is the PSI and I understand the PSI process. And if they're generating it in Domo, it's gonna have the checkbox on it and they're gonna submit. I guess I'm just confused if they're pulling off a paper, who's approving it? Are they just checking the boxes approved because they're using an approved form? Are they getting their supervisor approved? Are we gonna have the clerks deciding whether it's approved when they go file it? And then for my real purposes is the journal entry, which has the same boxes. How is that one generated and how do we determine where that is? And we can wait for that conversation too, but it's not just the CSO process. The same boxes are in each of the journal entries as well, both the probation and the regular one. And I guess I'm just unsure what stage that approved gets marked and who has the authority to mark it and what prevents someone, as suggested by the honorable judge, to just click the box anyways.
Well, I don't think you're not gonna be able to stop anybody from actually doing those things. We're hoping that they're gonna be operating with the ambits of their ethics and morals with regard to their job. And if properly trained, I can't see that would be problematic.
What does approved mean?
Approved is basically outside of the case app. So if they're not able to create that, so as I said before, there was a situation in which we are looking at right now, trying to find exceptions that could potentially place that outside of the case app. Obviously, the likely choice, of course, would be if that was a pre-2016, that PSI would have to be created, so would the journal entry, so would
Could we put variation approved or, indicate that the approval is for something outside the KSAP?
So could we put created in KSAP with the box or alternate form approved by KSSC?
we could do that.
Should we shorten it just to say approved by KSC?
SSC.
Approved.
KSSC, sorry.
Yes. We had to change that, remember?
Yeah, just, we don't have to say alternate, we could do form.
Yeah, just trying to think it'd be
Yes.
smaller and a little more appealing, at least.
This is the one box. we
What
could be
did you say,
working in.
approved by what?
Right.
KSSC.
So what is the verbiage again that you're proposing?
Created in KS app with the box. And then, or form approved by KSSC.
Okay. All right. Any other discussion on that? And we can move on.
Right, yeah, just because would it be interesting or maybe easier to see over here where there's room?
No, because you have your clerk
That's right.
stamp
Okay,
that's there, the
Okay.
electronic stamp.
thank you.
May I suggest maybe putting completed in case that, because sometimes I'll get emails that CSOs have created a case and then they realized, oh, it's a pre-2016 case or a misdemeanor case. So maybe created, but then they don't end up completing the form. So completed might be better.
Because the completed helps you get it for the data set to know that you have.
Right.
Yeah,
Yeah,
that's a good
that's
idea.
checked
I'm giving,
when it's
yeah,
filed.
that's a great idea.
Okay. Chris, you want to move on to Senate Bill 123?
Sure. And I can make those changes as well. If we can scroll down just a little bit, the couple of things we added here was we removed the description from special rules section here. And the reason was simply that it did not fit when it was typed into KSAP. And that was a request from, I think, some of the CSOs through Peyton to remove that. So now it'll just fill in with the statute number. And below that, the firearm finding, the 6 and 18 months. Well, there's a firearm finding now due to HB 2501. There's multiple firearm findings that can be made. And so the forms committee decided just to remove that specific language of G1 because now there's a G2, an H1, and an H2. If it is under G1, then you can simply check 6 months or 18 months. If it's not under any of those, you can just check firearm finding. And that was just to clear that up a little bit. Below that, there had been a discussion that was had of tracking offenders who had a prior SB 123 sentence. And so working with the forms committee, they said that it might be helpful to put a prior SB 123 box next to the SB 123 treatment. So we place that in there just for tracking purposes. Below that,
Just a moment.
under post.
I'm sorry, we have a question from Spence.
Thanks. So and I'll apologize to my forms committee, since I didn't think of this previous, but I did get an email about this morning because we only place that on the primary offense rather than the other offenses. And wondering, just working this out, if it might be confusing, like say at the secondary, the count 2 is the Senate Bill 123 case that makes this eligible. Is it confusing that they would only mark it on the primary offense that might be an aggravated battery? And then count 2 is a possession of drug. That you mark prior SB 123 on the non-drug offense or the case that wouldn't be eligible. I know with Senate Bill 123 plus that it might be eligible on the first count as well, but it might not necessarily be. So just thinking about is it the best place to have it only on count one? Or, and can that be confusing, or is there a better place maybe to mark it in the PSI?
So now you mentioned that, that's a good point. I think the purposes of putting it where it was just is to allow the court to be aware that it was a prior SB 123. So it was mainly for tracking purpose, not related to a specific count. Recall that discussion.
Yeah, and I agree with that. I think though that, you know, if I'm writing the PSI and it's an ag assault and I'm not, if it's not a Senate Bill 123 eligible case, just whatever that might be, that I'm probably not gonna even think about Senate Bill 123 and marking a section there. You know, that might be something, because I know it's not Senate Bill 123. I'm not even worried about that whole section of the PSI. Just want to make it so it's easier and for a PSI writer to know when to mark that case. And so if I'm looking at the case that it is eligible, it's probably easier for me to think about, oh yeah, they're mandatory and I need to mark prior SB 123 on that count.
So
So
is
the-
your suggestion, go ahead, I'm sorry.
No, go ahead.
So your suggestion is to put it with each individual count, is that correct?
And then, yeah, and then they would just mark it. And that, again, I know that could be confusing, where do we mark it on every single count? Do we just mark it on the count with Senate Bill 123 eligibility? Or is there, you know, if we put it on the recommendations page, that, hey, there's been a prior SB 123. I know, like under the community, and I'm just spitballing, throwing it under, you know, the community corrections, but marking just informational purposes only Senate Bill 123 prior case or something, whatever the word would be.
Yeah, I think both of those are a good idea. If you just wanted it just for the tracking purposes, that'd probably be a good place to put it.
So I always like to, if I may, I'm sorry. Make sure that the PSI follows with the journal entry. So I pulled over the journal entry. The journal entry has it under the list of questions. Number 16, I believe, is that where we're putting it? Was offender previously sentenced to Senate Bill 123 drug treatment under KSA 2168-24? There's a box, yes or no. So that line will be for every count. And if we don't have the box on the PSI for every count, it will be confusing as to whether that box should be marked. And I think the way the system works is the PSI is filled out for each count on that. And when the journal entry is generated, it's probably going to preload that response for each count. So it makes more sense to me to have it for each count as you do on page 1 of the PSI for the secondary page in the counts, so that it's preloading that journal entry if the change is going to remain on the journal entry.
And I agree, because each count, you're going through that analysis. And so I think that's good to have it on everyone.
So I think we just in the desk reference manual want to be clear. Do we mark, does the PSI writer mark it for every single count? Do they just mark it for the count that qualifies? And I think that's just an educational thing that needs to be clear in the desk reference manual when we move forward.
Well, the way we have it on the journal entry is you're answering this question for the count that you're talking about. So it has to be just for the count you're talking about.
Okay. Okay, Chris.
Any more discussion on that, or are we just gonna move on? Okay. The next thing you see is under post-release supervision duration. It says other. This was something I believe that originated from Sedgwick County, specifically. I think it was Aaron Breitenbach, who said there are some cases where they would like the ability to put no post-release at all. And so we added the other, and at the bottom of the page, we changed the date, the revision.
I'm sorry.
Sure. No.
Chris, can we go back to the other? Because again, I am about uniformity. So the journal entry doesn't have other. The journal entry has no post release. So if we're checking a box on the PSI that says other and we're writing something in, then I think for consistency purposes on the journal entry, we should have the same box with other and then let it right in. Otherwise, it's confusing as to which, and I know why they're doing that is because there's a lot of questions about off-grids. When you check the hard 25 box, some PSI writers, some CSOs think you should check some level of post-release, and actually DOMO requires you to do so. Whereas there is no post-release for off-grids. So we just need to be consistent between the two, whether it's no post-release or whether it's other where the attorney or the PSI fills it in.
We can make that change.
And I don't have a preference. I just think it needs to be consistent.
No, I would agree. I don't think there was another reason why it was other instead of no poster release.
Well, you can depart
Hmm.
to no post release.
I frankly
So-
liked the other box because when I brought this up a year or two ago as well, we tried to talk through what that would look like. And putting it in a box that says no post release makes there an impression that there's no supervision. So having the other box where the prosecutor can put what it is or the judge can make the order, whether it's a departure, and they can fill that out. DOMO still prompts you to fill it out, but then you can fill it out with the appropriate language from the court, because that's what's binding, as opposed to what a pre-filled box says, and be limited to that.
Okay. So for uniformity, change it all to other.
That would be my suggestion.
And this is Mark Keating real quick. We have seen where judges would check other and then write in 25 years post release, which is absolutely crazy, but they do write in other things beyond just none or dates that are listed there. They write in a lot of different variations. So judges do use that other a lot.
I don't know what to say to that.
Education.
So the change will be reflected on the journal entry.
Not on the PSI, yes.
Correct.
Okay.
So we can move on. Scroll down, please. These are the same changes that were made in the other offenses. We're going to add the SB 123 prior to each offense. So page 2 and page 3 will be identical changes. Here, there were no changes to that page, just the revision date. And then here is where the big changes come in. So looking at the special rules supplement, you'll see there's several new special rules and also some clarification of prior rules. And most of it is necessary because of HB 2501. So the statute, as amended, requires us to put an H1 under person felony committed with a firearm, so special rule 1, because now there's an H2. The non-drug, non-person felony committed with a firearm, and that's now a suppression device or shotgun less than 18 inches upon the finding of a trier of fact. That one is 216804H2. And the special rule number 58, this is just the order in which we came across them. So there's nothing special about that, the number itself. And then 32 and 56 were changed as well. So 32, firearm carried to commit a drug felony or in furtherance of a drug felony is G1A now. And firearm carried to commit a felony, and that's the suppression language. And the shotgun less than 18 inches is G2 under 216805. And then special rule 33, that statute number changed as well. So that's now 216805 G1B. And what these are just lining up to the new language. Then yes, Judge.
I had a question on that suppression device. Should that not, to be accurate, should that not be noise suppression device? Or are there other suppression devices that are also outlawed?
I'm checking that language right now. The exact language is equipped with a device designed to suppress the report of the firearm. So
that would be a noise suppression device.
Okay. And we can make that change, Judge.
Thank you.
So noise suppression device, and we would add that to 58, and we'd add that to 56.
Do we think that adding the word noise is going to add more room for argument as opposed to just keeping it suppression device? I don't know enough about guns, I will admit that.
Well, if the statute says it is suppressing the report is the sound that the gun makes. So it is a noise suppression device. People commonly call them silencers, but the technical term is a noise suppression device.
Okay.
At 35, ag endangering a child, there was a new section added to the endangerment. And so it was another penalty. So that kicks down and makes this now C4. So we made that change. The transnational repression, we called that 55, Special Rule 55. And what that does is enhanced one severity level. And if it's a severity level 1, it's a mandatory minimum of 25 years. It's upon a trying of fact. And that is found in 2168-4. And you'll see there are a couple of places where it says 6804 CC. And I think we're waiting on the revisor to clarify how that's going to turn out. CC is the last place in 2160-04 you can actually place a new language. And I think that's why it was used multiple times.
I have a question. Chris,
just a second.
Yes.
On that section, we talked about this last year about adding the upon finding of trier of fact language to each of them, and that was done. And then when the newer things were just added, it's just about placement. And I guess I'm going to be ticky-tacky about it. On half of them, you have the upon finding of trier of fact at the end of it. On half of them, it's at the beginning of it. I think for consistency's sake, it needs to be either one. And I think placing it at the beginning like you did for number 1 should be the consistent, because that should be the first thing that flags it. Upon a finding of fact, sentence pursuant to. And I think for all of them, and I highlighted it's 36, 48, 50, 51, 52, and 53, and 55 that was just added. Those were all flipped it to the end. So half of them at the beginning are in the front, half of them at the end are in the back. If we're going to change it, I just would ask that we just be consistent.
Yeah, absolutely. I can make those changes.
And I like it at the front, because that's what we talked about. I know Jessica Glenting is on here, is that was the first thing that needs to be considered. It's not just if it was, it's whether it was found by a finder of fact.
Absolutely. And that's where I'll put it, Jessica.
Thank you, Chris.
You're welcome. I think we scroll down. I am not sure what else we had. Oh, yeah, 57, a new special rule. So this is the non-drug felony committed while incarcerated on probation, parole, conditional release, or post-release supervision for a non-drug felony if there's a criminal history score of A through E. And then it's the new sentence shall be composed consecutively. A new crime is a felony. Court may impose prison, even if presumption is non-prison. And once again, you'll see it's 216804 CC. So that'll probably change. The CC will.
Spence?
I might have read it wrong, but doesn't the bill state that that's a presumptive prison case? If it's an A through an E and there's that it's presumptive prison versus may impose prison. I could be wrong.
I'm pulling it up right now just to double check, Spence. So the exact language is the sentence for a felony offense committed while an offender was in custody for a prior non-drug felony or on probation, assignment to community correctional services program, under suspended sentence or on parole or post-release supervision for a prior non-drug felony, and when such offender's criminal history scores in A, B, C, D, or E, shall be presumptive imprisonment, regardless of the grid block for such current felony. A sentence imposed pursuant to this subsection shall be served consecutively to any other term or terms of imprisonment imposed in the prior non-drug felony case in which the offender was on probation, assignment to community corrections, etc. Such sentence shall not be considered a departure and shall not be subject to appeal. So
Instead
it's
of
presumptive.
Instead of may impose, I think we need presumed prison, correct?
Yes.
Words matter, right, Judge Hill?
Amen.
I'd propose then that we change that.
Great.
Thank you. Good.
Yes.
Appreciate that.
Okay. And one of the other things, if you scroll up just a little bit, I just so that you're aware, a little bit further, please. When it comes to the registration offenses, one of the offenses was the sexual extortion, right there. And that's on the right-hand side, fourth one down, 2155-15. This is one where aggravated sexual extortion, which is a new crime, did not make it as a registration offense. We talked to the reviser about that. And I think he replied to Scott that that's something they're going to have to work on. So there were no changes necessary on this form to add the new offense.
Did they add child abuse? I thought they added child abuse.
To the registration offenses, I do not recall that, Jessica, but
I don't believe there were any registrations that were actually included in the sessions. And that was one of the part of the issue that, like with the extortion, we anticipated that the core would be amended and it wasn't. And so they've indicated it'll be probably a technical amendment, I would imagine, next year.
Okay, because I thought Child Death Review Board had announced that child abuse was now a registrational offense, but what you're saying is potentially they did the first part of that language and forgot to amend Cora to.
Yeah.
Okay.
then you scroll down. Okay. So there was a request, and I cannot remember where it came from, to add anticipatory crimes under the current crimes of conviction here. And so a new column was added with an A, a C, and an S. So that could be marked. Further down, and these are just, I believe, additional pages. And I'm not sure if there's any other changes after this. Okay. And that would be it for the PSI.
Judge. Chris, to that point, do you think that you need to include that in the explanation of codes below as to what an A, a C, and an S is? I know what they are. I'm just saying we explained everything else. Do we need an explainer, or Is everybody gonna know what A in that box means attempt?
Well, since everything else is explained, we might as well explain that as well. I think just for consistency purposes. I can add that language in there.
It gets easier from here.
Where are we gonna put that?
The second page of that form has it's page 10, have all the codes at the bottom. I would request that we include it there where all the other codes are listed.
Yes.
So just under where the other definitions are on the next page. Is that correct?
I think that's the best place for it, but I
Okay.
mean, I'll leave it to
No,
staff.
that's okay. We'll just put something in there. Okay, so that is it for the PSI. I'm not sure if I missed anything, Scott, but I've
Chris, let's go
notated.
ahead. Sorry, go ahead.
No, I'm sorry. No, I was just saying I notated the changes, and I can make those changes and get those out to you.
All right, let's go, since we made multiple changes, let's go ahead and vote on the proposed changes to the PSI form.
Also move as amended by this body today.
Second.
All in favor?
Aye.
Aye.
Any opposition? Hearing none. This is approved. All right, go ahead, Chris.
Thank you. So here, once again, we have just the date change, and this is the sentencing journal entry we're looking at. And then language we discussed that we can change to, I believe the final language that I have written down here is completed in KSAP and form approved by KSSC, where that new box language is at the top. And then we can scroll down, please. Once again, we remove the description from the special rules, just for space, and for KSAP, they'll be marked on the special rules page. Please scroll down. And this is the box that Jessica had mentioned earlier. Was offender previously sentenced to SB 123 drug treatment? And it's a yes or a no box. So we actually added a separate line, number 16 here. Under section 4, under the sentence imposed, once again, we had to change the G to a G1, and that's just because of all the work that was done by House Bill 2501 on the firearms, and so that's more exact, more precise. And then under 3, post-release supervision term, we are going to change that to other, I believe. So let me mark that real quick. Then the revision date, that is 7/1/2026. So this is something that was requested by, I believe, originally Sedgwick, but also it was discussed in the Forms Committee, and that's adding a comment section. And if anyone wants to go into any detail, is just to add any other comments about either restitution or any fines or costs, and that way a judge can write what they want explicitly done, and that's why that box was added.
Yeah, this is mainly in a joint and several situation with co-defendants as far as restitution ordering was the main reason, and I'm sure there's others probably.
Judge.
Yes.
Chris, up above
Yes.
there on your restitution boxes, do you see the formatting gaps there down below where it says ag human trafficking and then there's a big space before the statute number?
I do now.
Yeah, and then down
Yeah.
below that there's the same. So I think that's just a typo error if we could just get it to flow.
Sure, we can fix that.
We were also going to fix the
The lines on it.
lines, yes. So some of them are bolded and some of them aren't. under the costs.
And then if we scroll down, once again, we'll change that post-release language to other. And below that, we made some language changes to that checkbox. It said previously, I think, defendant advised of prohibition against firearms. Well, the statute, we wanted to make it a little more precise. So now it is defendant advised of prohibition against weapons, open parentheses, firearm or knife, close parentheses, and that's 216304. The Forms Committee thought that would be more precise and descriptive. The revision date again. We can scroll down. So if you, we can go back up. There was the other way. Could you go the other way quickly to the signature blocks? So this is something that, and I may need a little help on this one, Scott, because now there's no physical signatures. And so what we did is remove the judge's signature. We removed the prosecuting attorney's signature and the defense attorney's signature since it really wouldn't be necessary. So that is one of the changes we made there. You can scroll down. Once again, under the additional offenses, the description is not necessary, so we remove that. And you'll notice, okay, let me see. Under the prison term here, more precise language would be G1, so 216805 G1 due to the changes that were in House Bill 2501. And we scroll down. Okay, so these will be, and there's going to be, these are the exact same as are on the PSI. So I'll just make all the PSI changes and attach them to the sentencing journal entry. So we just have to do it one time. So we don't really need to go over the special rules supplement here.
Judge, I'm sorry.
Go ahead,
Chris, you're
Jesse.
quicker than me. I'm sorry. On page 2 of your secondary offense, which is, I think it was right before that section, right? Yeah, right there. Where you have your post-release supervision term, can we add an other box there? I didn't see that was added on our supplemental pages.
Oh, absolutely. Post-release. Yeah, I'll make sure that's there.
Chris,
Thank you.
Chris, I also have a question.
Yes, Judge.
If no judge is going to sign this or signal approval in any way, how can this constitute a judgment of the court?
Well, Judge, I am not, this is developed for Domo, so I am not sure of the workings of how that's going to work. My understanding was once it is signed off on by the parties, then it would go to the judge, and the judge would simply click a button, and then it would be filed. I've not seen the actual operation work out, so I assumed by doing that it would be made a judgment of the court and binding.
Well,
But that's a great question. I'm not sure.
That it's a fundamental question that is I cannot answer.
well, Judge Hill, we don't physically sign them now. They come to our queues, and then that cover sheet is attached to the document for filing, saying it's indicating that we've reviewed it, and our signature is on that. But Scott, you have more to add.
But there is some sort of designation of court approval. And here, if I'm reading this, I see nowhere where the judge approves it.
Can we go back to that signature block?
So currently, when we do it through the Domo system and present it, that we check that box when the judge approves it to show that they're looking for that electronic signature page on top. Sentence, as you know, is complete upon pronunciation from the bench, period.
That's
So the
correct.
journal entry is just a reflection of what the court's order is. And when it's approved with the cover sheet is when it's approved. So that box for submitted for electronic signature, that might need to be reworded as approved when we actually have the embedded system through, because
I think the approval, there has to be some sort of judicial approval somewhere, whether it's in a cover sheet or some that'll tie it in, because otherwise, how can it be a judgment of the court?
Yeah, Judge, the KSAP was originally developed to actually have judges in the system to be able to, when it was transferred by electronic means to the judge, that they would sign off within the system. After conferring with OJA, they wanted to seamlessly integrate that with the eFlex, so that they could get misdemeanors and other, obviously other pleadings from other types of cases that would be consistent with what they currently were doing in the e-file system. So that is the modifications that we actually made to keep them out of having to actually set up. They have a profile in the system, but it is actually forwarded to their queue just like any other pleading would right now.
And we deal with queues all the time, but there's a way for the court to approve an order in the queue, and that approval is recorded. I just didn't see here that it was approved. Now, it may be listing a judge, but does that mean that judge approved that? Is this the order of this court? You know, that's my only question. If you can make it clear that it's approved either on this sheet or by some cover sheet, that satisfies me. But I just wanted to bring it up.
Cover sheet.
I don't believe that Domo changes the cover sheet.
No.
That will still be added.
Yeah, and we're still testing the integration so we can ensure that when it comes back, the approval from eFlex, it comes back through from the judge, that the cover sheet stays. And then that's also how you would know that it's completed and has been signed by all parties too.
so the button here only says that it's been submitted to the court for signature. It doesn't say that it's approved. You have to have the cover sheet approval page for it to be the order of the court. But my secondary concern is that we don't have any such button approved by the attorneys. I mean, it's just their name is printed, and I am responsible for ensuring that by signing that or something, clicking a button or something, I am approving that for submission to the next party. Defense counsel has to approve it. Having their name just printed in there, I mean, I suppose, but it doesn't say that either of the attorneys approved it either.
Well, number one, I don't think defense counsel does have to approve it. They should, but they don't. It's not gonna stop there. It's still gonna come on to me after they've passed a period of time, correct?
Yeah, once prosecutor, they'll have to click enforce rule 170 and that button pops up after 2 weeks. And then it does note when that's clicked enforced rule 170 in the defense attorney box. As of right now, signatures are still, as an e-signature, they're still, like when a prosecutor signs it or submits it, that signature is attached on that signature box right now. And same thing with defense if they go in and approve it or submit it.
So it actually does sign it. So it's not printed, it's signed and printed.
Right. Yeah.
I just would like that to be consistent.
Do we need to add this signature?
Can you repeat that?
Do we need to actually okay. I don't know if you're asking Peyton to repeat or for me to repeat.
You, Chris, sorry.
Okay. So is it should we just put the signed line back on there and maybe a box at the end of it? Or
I don't think you need the box if you have the signature. I mean, if we're still doing at least one signature and then we're noting for defense counsel if they're doing rule or they're doing their signature, then that is fine. But if we're not having either and it's just having names listed, then the court is not made aware that it was submitted and then ruled. Or submitted and signed.
It is an actual copy of a person's signature, would be in the signed line?
It's an e-signature. It's
Yeah.
automatically
Oh.
populated. So it's not your exact signature.
Okay, that's good. I just wanted to make sure we'd be able to read it.
Yeah.
Okay.
We could
Yeah.
put a signature line above printed.
And I think printed is on there as well. Like, I think it's printed and signed. I'll double check, but I know the signature is in there as well.
So we want to add signed above printed for both prosecutor and defense attorney?
yes, I can add those. And do we want to make any changes with the judge?
Judge Hill, if there's still the cover sheet, do you have any heartburn about leaving this box the way it is?
Yeah, or if I don't know how these things go. If that cover sheet disappears,
We can, we'll ensure
It's
that
not gonna
stays.
disappear.
Yeah.
Everything stays the same on that side.
Everything stays the same on that side, according to Scott.
but you have to, my point is, you have to have the two together in order to show the approval of the judge that this is the order of the court. And,
Yes,
and that's the important thing, to have the two together, or put some approved by the court per or whatever, or something like that. But that, you see my dilemma.
Yes.
And I'm also thinking about, I don't know if I would be reluctant to approve an order that is submitted to me that has not been approved by at least one counsel.
Well,
and
it
looking
can't-
at this, I see no approval by either counsel, which is what you were trying to say earlier. And I had not thought of that.
It can't get to the judge unless the prosecutors approved it.
How do I know that?
Judge, we're gonna have a signature line added.
Okay.
So we're gonna add signature for at least the prosecutor. We're gonna add it for defense counsel too. If they don't sign it, it'll say rule.
Rule
170.
170, yeah.
Yeah, Rule 170.
And then it goes to the judge. Throwing this out here, and I know we don't wanna leave it open. But there have been times where I've completed the journal entry and defense counsel has completed the journal entry through Domo. And then it's been printed and a judge has signed it. And then it's been filed. So we're saying because of the legislative change that a judge cannot sign the journal entry. Yes, he or she has to physically click the button in eFlex in order to be able to submit it. Because there's no signature line here for the judge either.
Well, the judge could still, I suppose the judge could still sign a physical copy, but when it comes through the judge, it's still gonna have to be submitted through the queue to be filed electronically, which would add the cover sheet. So
Are we to assume then that everything that's filed has been approved by the court? Is that what you're saying?
yes, it can't be filed with the
What
court
prevents
until
that?
the judge has approved it.
What prevents that?
Because it doesn't go through e-filing until the last stop is the judge. And so it will not
And
be.
what must the judge do to? Is there a box to click, or or sign that cover sheet?
The box to click automatically signs the cover sheet and files it, which date and time stamps it.
Well, is there a necessity for a cover sheet? Or what if you had that same box here?
Well, these are being filed in PDF format. So
I
if
see. Okay.
if
Yeah,
OJ
okay.
wants to, they would have to modify them in some way to be able to do that rather than put the cover.
My
Yeah.
inclination right now is approved by the court on sometime, approved by the court through electronic signature, of some way, some sort of designation on it, on the PDF form. I just feel more comfortable about it.
Well, the only instance though is that you have is a possibility that, and that was one of the things we talked about specifically as far as the programming is concerned, is that it actually pings the judge's queue if the judge doesn't sign off on it. And so we actually get a ping saying judge has signed off on it. It automatically will close the case on our end. If the judge doesn't sign off on it, the prosecutor then, of course, gets a notice, I presume, in eFlex that it's not been signed, and then they can actually file an amended journal entry as a result of that. If there's something that the judge sees that that's not what I ordered from the bench, something's amiss. So there is. Go ahead.
Can I jump in right there? And I was waiting, and you just gave me the opportunity concerning that notice. The biggest issue that my prosecutors see with Domo is the lack of notice. They're struggling with knowing when the judge signs, if the defense signed, and the defense doesn't know when the prosecutor signed. And so it's literally a kind of toss of the hat, and whether or not one of our assistants goes back and check to see if everyone signs. And so as we're doing all of this, if we could, touch on that to make sure that once that button is clicked, whether it's the counsel from defense, prosecution, and even the judge, that folks are being notified, so they're not just waiting and aloof and we've had that situation where we're kind of getting chewed out by judges because defense counsel didn't know that it was signed or prosecutor didn't know, and thus the judge didn't know. And so, and if this glitch has already been fixed, please let me know. But as of last week, I was dealing with this in Wyandotte County.
We do have notifications that are set up within the system. And then once the judge signs it, there should be notifications through ePlex like you would normally get with all the parties that are subject to that particular case. But we can take a look at that and see whether or not that's, if you're saying it's not happening, then we'll have Peyton get in touch with you.
And it shouldn't ever go to the defense attorney if the prosecutor hasn't already approved it.
Yeah. So once we've signed it, the defense doesn't know that we've signed it, and so they're not getting notice. And then once the judge, or rather the defense, signs it and the prosecution, sometimes the judge is not get notified. And so I don't know where the ball has been dropped there, but literally at this point, what we're doing is having my assistants, my administrative assistants, to just keep an eye on it, to then send an email to whichever party is next. And because we're trying to make sure we do everything through Domo, so we notify those folks, hey, jump in Domo and do it, because Domo or whatever the process is not letting them know. So as you're messing with these things, just keep that in mind.
Okay, well, Scott said they'll look into that. My guess is that defense attorneys have their notifications, or not paying attention to their notifications, but they should be.
I know I've gotten a couple emails that I don't think people with Outlook are having an issue, but I think Gmail is having an issue, and they're either going to spam every time, which we can't really do anything about on Domo's end, or they're not getting them. But also once we're integrated with eFlex, I know some prosecutors have made a comment that they don't get a notification back when a defense is signed, so they don't know when to file. But that will be solved once we're integrated with eFlex, because it'll be automatically filed when defense submits it.
Well, if that's the case, I think that even just sending out information that those changes are going to be made, or these are the current or common issues, it would really bring some ease, because right now it's prosecutors trying to defend to the judges, and then the defense bar is yelling back saying it's not us, judge, it's the prosecution. And so, and in essence, I think it's just the technology just trying to catch up with everything. And so just if that little form of education, it would cause, or excuse me, it would stop a lot of small fuss for something that nobody has control over. And I'm always willing to blame defense lawyers for it. I just want to put that out there. I'm sorry, Jessica. I just had to put it out there. Yes, it's defense fault.
Mark, I'll have Peyton follow up with you on that, okay?
Thanks a bunch.
So I'm not sure how far down we got on this form. I think we got to the supplements page and said they would be the same. We can keep scrolling. There was a small change, a tweak under felony domestic battery to a subsection, so we changed that as well. So 54C1C, and that was changed on the other forms as well on the PSI special rules page. And keep scrolling down.
Judge,
Yes, that's,
just real curious, is it with moving the case app, are the intentionally blank pages still necessary? Just because it always, when you print a PSI or a journal entry, it always just seems, we have several blank pages. And is that still needed with the new case app?
Why do we have blank pages?
I wasn't going to ask that
I
question. I was
include
going to
them, but
pretend
I don't even know
I
why.
knew.
It's a great question.
Were we
I don't
just,
know the answer to that.
were we just used to like 3 pages, and so we made sure that we included a blank page so people felt like, I don't know.
That was actually
What?
Yeah.
well, I can
Notes.
say that the forms committee, we talked about, because it's electronic, moving count 2 under count 1 as opposed to the way we have it now. I assumed that also the issue of this page intentionally left blank was part of the issue, which the forms committee decided to table for now because we needed to find out what the cost was to change the app. And we certainly, could we add that to our inquiry about that?
Yeah, we certainly could. Frankly, I don't know whether it was the way that it was actually printed on paper that there was a requirement, but it's been that way for a long time.
It was because of, so that we have the special rule page, back, front and back, because those are kind of separate documents. Same with the registration.
That's exactly why.
Yeah.
It's to separate the three, the journal entry from the additional offenses from the journal, the special rules. And then the offenses, because they're not always needed in every single journal entry.
So they were just pulled
Yeah.
out.
I used to even do them separately on the website, and then we quit getting requests for them. So we just.
So it's possible that in an electronic format that that could be a possibility that we could delete those. Right now, we do have it set up from a I wouldn't say logistical, but for the most part, logistical. So those sex offense supplements aren't going to show up, or the special rule supplement. If there's no special rule, it won't show up in the same thing for offender registration supplement. If it's not there, it won't show up on the journal entry. So we're trying to minimize the amount of stuff that practitioners look at, and that's one of those things. And this possibly certainly could be another one of those things, since there's no content on either of these 2 pages.
So we'll look at removing those.
In addition to pulling the additional offenses prior to the recap of sentence.
Getting rid of that page and, intentionally, is just a matter of getting rid of that option in a Word document. Remove page.
Okay,
That's simple. Now, whether we want to have the ability, because it's also helpful in the DRM, when it's printed out as well. So that was the separation idea.
Okay, we can check on that.
okay. Anything else?
I don't believe there's anything else on the journal entry of sentencing.
Okay, I'll take a motion to approve the journal entry of sentencing as amended by this body today.
Move.
Second.
All in favor?
Aye.
Aye.
Opposed? Hearing none, we will amend it accordingly. Go ahead, Chris, with a PV.
Sure. I don't see it on my screen yet on the.
Oh,
So there are very few changes on here. One of them, of course, is the year, the amended box. The KSAP filed and approved, that was just an open space we had. So I can change that language to match the language in the other forms. And we scroll down. Revision date was changed. Signatures, I'll have those adjusted as we discussed before. And that was it. Any questions on that one?
seeing none, I will hear a motion to approve.
I will move.
I will second.
All in favor?
Aye.
Any
Aye.
opposed? Opposed? Hearing none, we will amend this as passed.
Thank you, and I'll start working on those changes and get them out to you.
Thank you, Chris,
Thanks, Chris.
and
You're welcome.
everyone else who helped with the forms. All right, Pat?
All right, short and sweet. As you know, a very important bill passed, 2192, that requires that in a misdemeanor conviction for the batterers, domestic violence, that they have to be analyzed for whether treatment is necessary. And so a group has gotten together, two representatives from the AG's office, the head of the statewide Domestic Violence Association, the head of Victim Services at the Department of Corrections, and myself, and Dorothy Halley, who gave us a presentation in our, general overview, to ask the question, would it be possible to get the legislature to actually fund the testing and perhaps even the service, because it's so similar to what we do in Senate Bill 123 for felony drug possession. And felony drug possession is an 18-month program. The batterers intervention programs are 6 months, substantially less expensive. And there's about 15 or 20 organizations around the state that do provide batterers intervention treatment. And the question is whether or not the legislature would be interested in making sure that this testing gets done, and then possibly that the treatment gets done as well. But at least start with that there is completion of the testing. The testing that was done last year in the Office of Judicial Administration provided the information to our group of, that there had been 1,200 individuals tested in 24 and at the misdemeanor level for a first-time domestic violence offense. And there were 1,000 tested in 25. And those are sort of the numbers we have. And what I thought was important to do today was to tell you that this was sort of going on and moving forward. And to see if anyone on the Sentencing Commission has, a concern, a question. The concept would be, the way this is organized, that unlike Senate Bill 123, the actual approval and licensing of the treatment centers would remain with the Attorney General's office, their Victim Services Division. But the payments and the administration of a program to either pay for just the testing or to pay for the testing and the treatment would be administered like Senate Bill 123 through the Sentencing Commission. And I don't know if the legislature is going to be interested or agree to it. As you know, in House Bill 2192, they changed the order of business for people who have a conviction of battery and indicated that they must be tested and must go into treatment. But whether or not those folks can afford and whether or not that will come to pass is difficult to know, but certainly they'd like to consider the possibility of the legislature aiding it with some funding. So, but if anybody on the Sentencing Commission has concern, I sure wish they would contact me and let me know, what the concerns are. If anybody has something now that they'd like to add or ask. As I say, this is sort of very early stages. It's on the heels of the passage of that legislation that requires that there be the testing. And it's a look of, could we just run this thing the way we run 123? And give that kind of protection that we give for felony drug users. Could we give that kind of protection to the victims of domestic violence? So that's kind of what's cooking. If anybody has a comment or wants to let me know of something I should follow up with or consider, I'm all ears.
I would just say that is by far the number one not deterrent, but issue that our clients have, right? They can't afford it. And it's extremely expensive to do 26 weeks of treatment, let alone the evaluations. And if we're here trying to stop people from committing offenses in the future, going to prison, it needs to start at the misdemeanor. Because we by far have more misdemeanor domestic batteries than we do felonies. And you either get a serious domestic battery or you have 3 misdemeanors before you get a felony. And if we can stop it at the earlier stages, it totally makes sense. I know there would be nobody in court services that would complain other than the work itself and getting it done. But to have a program like this would be wonderful if we're looking at stopping recidivism, or at least helping with it.
My question would be, Pat, how one of the bottom line is, do you have any idea, just based on current census, of what that fiscal note would look like approximately? I know it's going to fluctuate depending,
Sure.
just to get us started.
Last year there were 1,000, and the cost for the initial testing would probably put it at, a couple $100,000. The 26-week course would probably be, to do it all, would be probably about $1 million, $1.2 million. So we're not, Senate Bill 123 is about $3 million a year. Wouldn't you say, Scott?
No, it's
No.
about,
How much?
it's about 14.
14 million?
Yes.
You're kidding.
Yeah.
Okay, but we don't even have that big a budget for the Sentencing Commission.
We do. We have a $16 million budget.
Oops. I missed that
Still
part.
recording.
Okay, yeah,
It's
no,
all
I think
passed.
we're looking at
Separate
$1.5 million or so for the treatment, and what I'm basing that on is that there were 1,000 cases, your office, Spence, put the numbers together. It was 1,200 cases in 25 and 1,000 convictions in in 25 and 1,224 it went down. But it costs between $1,000 and $2,000 for the 24-week treatment, 24, 25, 26-week treatment. And really the difference is the ones in the bigger metropolitan area charge more, and the ones in the more rural areas charge less, but $1,000. So if you were to take $1,500 and add that for 1,000 cases, you'd be at $1.5 million for the treatment. The testing, I haven't really got a good number, the exact for the cost of the testing, but call it $100. You know, maybe it's, what would you put it
So
at?
I would say 3,
300?
yeah,
300?
at least.
Okay, and there were 1,000 cases in 25. So that's 300,000.
Or does that number contemplate the domestic batteries that are within a felony conviction case, or are those just only misdemeanor conviction?
We really were looking at first time misdemeanor. That's really what this is about.
The other issue.
Stop them early on is the concept.
The other issue, and I think like Senate Bill 123 has helped with having more providers. You look at some of the areas, our providers, it's very, we don't have providers locally. So if there's not options to do virtually, which a lot are driving 2-3 counties away to do treatment every week. And so, and I would hope that if we have a program, we could get more providers online, that issue.
So yeah, and so this is really at beginning stages of discussion, but it does have the interest of the Attorney General's office. It has the interest of the Domestic Violence Statewide Organization, at the Department of Corrections. And so I do think it's something that is going to come forward. There are a couple of legislators, including the one I spoke to most recently was Schlingensiepen, who wants me to immediately get a bill drafted. And under his authority, he said, call up the revisers. And I said, well, this is still in the beginning stages of getting the support for it. But anyway, it seemed like a natural to look at this for the Sentencing Commission, given the success we have had for Senate Bill 123, and whether or not we can be a follow-on with the matters and domestic violence. So please let me know if you have any comments or concerns, or, if you need information provided.
And this group, you're meeting when?
Well, we're gonna have a meeting after this. We'll meet in June, but the date isn't fixed at this point. And I was hoping that maybe in our September annual retreat, at least a portion of it might be a real update, because that would be shortly before legislation would actually be filed. Where we could really see and have what the course of this is developed into.
All right, so have people email you or contact you in some way if they have comments?
Yes,
Okay.
yes, please.
All right, thank you. Right, at this time, we would like to go into executive session. I would like, I would take a motion to move into executive session.
For how long?
And
10 minutes.
does it speak to a particular area?
Yes, it would. We're talking about a bonus for executive director.
And who might be able to stay? And because it would go offline, I guess you'll go offline, but
Yes.
for what the period of time?
We'll go offline and stop recording for a period of 10 minutes. Only the executive members can stay in for that conversation. And so I would take a motion for that.
Just for clarity, point of information, please, Judge. How do we handle those that are joining us by Zoom?
They would, the people who are not allowed into the executive session would be put into a waiting room?
Yeah.
Yes, and the other members would be allowed to stay.
Thank you.
I'll move
Second.
In favor? All in favor?
Aye.
Any opposed? Okay, I will ask that those members who are on the Zoom, who cannot stay in the executive session, be put into a waiting room for a period of 10 minutes. It's now 3:02.
You have the report.
Oh, you get phone.